said, document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah.
All right, y'all. Welcome back. Welcome back to another video. Now, we're not going to overtalk it. We're not going to overdo it. We're here to get into Armon Wiggins versus the NOT. Now, y'all already know about my copyright disclaimer. Y'all already know about my QR code to my X page. Let's get right into it. Now, this is going to be a lengthy video. It is 134 pages. It is a plethora of exhibits towards the end. So let's go ahead and get started. So if y'all are in for the long run, long haul, go ahead and get your snacks, grab your drinks, get you a quiet area, have a seat, and let's get into this read. Now, this is the declaration of Petitioner Armon Wiggins in support of civil harassment restraining order. Respondent has physically assaulted me, threatened me with violence, and repeatedly targeted me, both online and in person, over a multi-year period. He has tracked and filmed my movements, including at courthouses where I am present for my work. In November of 2025, respondent threatened me inside a federal courthouse bathroom, and the presiding judge halted trial proceedings to inquire about the threat that had occurred. After being personally served with this action, respondent escalated further by publishing my home address and phone number online, resulting in an additional harassment and fear for my safety. This pattern has caused me ongoing distress and a reasonable fear of future harm. This conduct constitutes a knowing and willful course of harassment under Code of Civil Procedure Section 527.6, including threats of violence following surveillance and conduct that seriously alarms and harasses me and serves no legitimate purpose. All right, so let's get into the declaration here. I, Armon Wiggins, declares as follows. I am the petitioner in this matter. The facts stated herein are based on my personal knowledge unless otherwise stated. If called as a witness, I could completely testify under oath thereto. This declaration is submitted in lieu of live testimony pursuant to, and as y'all can see, that is a quote from another court case. I submit this declaration to provide a complete chronological and clarified factual record in support of my request for a civil harassment restraining order pursuant to Code of Civil Procedure Section 527.6. This declaration adds material facts, precise dates, direct quotations, and additional conduct that occurred both before and after respondent had notice of this court action, including retaliatory conduct following service. Respondent's conduct is not isolated or occasional. It has occurred repeatedly over an extended period from 2023 through 2025 and includes in-person confrontations, threats of violence, filming and tracking my movements, online targeting by name across multiple platforms, and retaliation after service by publishing and distributing my personal information. I am submitting exhibits, including but not limited to screenshots and video links reflecting respondent's own words and conduct. Where I quote respondent, I am using his exact words as shown in those materials. Without a temporary restraining order issued, petitioner estimates that the hearing will require approximately 4 hours. With a TRO issued, petitioner estimates 1 hour, as the issues would be significantly narrowed and fewer exhibits and testimony would be required. Okay, so let's get into the procedural history. I initially request on December the 1st of 2025. The TRO was not granted. A hearing date was set for December the 18th of 2025 regarding the CHRO. There exists no relationship, Okay, so number two, which is procedural history. Well, number one, I'm sorry. Number one was procedural history. Number two is there exists no relationship. Okay, so let's get into the details. I am an independent content creator and journalist with a YouTube channel. One of the topics I cover for my audience are high profile court proceedings. I attend the trials at courthouses in order to do this. Respondent is also a content creator. We do not collaborate, coordinate, or maintain any professional or personal relationship. Any incidental overlap in courthouse locations does not give respondent permission to confront me, threaten me, follow me, surveil me, publish my personal information, or mobilize third parties against me. I first became aware of respondent through YouTube in or around early of 2023. I briefly interacted with respondent online and met him in person for the first time in July of 2023. Our relationship was brief and limited. We were acquaintances for a short period of time and were never close friends. During that brief period in 2023, respondent was offended. When I asked him whether it is true, he turns on his friends and colleagues because that is the reputation that precedes him. He became enraged, and I would not tell him all the people who said that. I disengaged as a result. After I disengaged, respondent's conduct escalated into fixation and repeated targeting of me both online and in person. But simply, he is completely obsessed with me, as evidenced by the amount he posts about me or with my name. 3, September of 2023, which is the physical altercation situation. So let's get into that. After that, on or about September the 16th of 2023, respondent and I separately attended a public event related to Zeus Network. We did not arrive together and were not socializing. During this event, respondent approached me at a bar while I was minding my own business. I asked respondent to leave me alone and then to get out of my face. Respondent ignored my request and later shoulder bumped me. Event security was summoned and decided that respondent needed to be removed from the venue. As respondent was being escorted out, he assaulted me by throwing a drink on me. A physical altercation occurred immediately after respondent threw the drink. Third-party intervention was required to stop the incident. This incident caused me fear and concern for my safety. It was physical, confrontational, and intimidating. On or about the following day, respondent posted online content about this confrontation and portrayed it as something he welcomed and encouraged. For example, respondent posted on Twitter a video of me arriving at the event the day prior with the caption, Armon Wiggins and King Payne didn't want no smoke when it was space and opportunity outside. This demonstrated that respondent had recorded my movements and arrival. After this incident, respondent began repeatedly posting content claiming he, quote unquote, beat me up and suggesting that future encounters would involve fighting. See Exhibit 5. Now, as I mentioned at the top end of this video, there is a plethora of exhibits. It is 134 pages. Okay, so we're going to get into it. Okay, so number 4, efforts to avoid and de-escalate. After September 2023 incident, I did not initiate contact with respondent. On one later occasion, when I unexpectedly encountered respondent in public, I responded to him with an attempted to de-escalate the situation to avoid further conflict or harassment. I suggested taking photos together solely to claim the situation and prevent escalation, not to continue a relationship of any kind or acquaintanceship. I did this because I know he lives to get attention from me. And so I tried to fulfill that strong desire. Sadly, that effort did not stop the conduct. Respondent continued to target me. Now we're going to take a pause because we did see on Donat's rebuttal, we did see his camera roll and we did see those 5 photos. And this is what Armon is talking about to relate to that particular incident. Okay, so let's continue. Number 5, request to stop contact and blocking. Due to his continuous harassing conduct, I blocked respondent on YouTube in or around September of 2023. By June of 2024, respondent was harassing when he was contacting me and accusing me of odd things, such as that I was competing with him. I told respondent that he was competing with me on his own and never the way or the other way around. I have never, including to present day, viewed respondent as a competitor. On June the 12th of 2024, I explicitly told respondent via Instagram messages to stop contacting me and to leave me alone. I blocked respondent on Instagram in or around June of 2024. I blocked respondent on Twitter, also, as y'all know, is formerly known as is X, formerly known as Twitter, in or around June of 2024. Despite being blocked and explicitly told to stop contacting me, respondent continued referencing me publicly and escalating his conduct. Respondent continued to target me. 6. Pattern of repeated online harassment over multiple years. Respondent's conduct in a long pattern of harassment dating back to 2023. It did not stop after the 2023 fight. It continued repeatedly through 2024 and intensified in 2025. From 2023 to 2025, respondent has repeatedly posted hostile, threatening, and harassing content directed at me on social media. This includes YouTube videos, live streams, posts on X, formerly known as Twitter, and other posts. This is not about one post or one video. I have much more than 60 videos, tweets, and posts in which respondent harass me, mentions me, insults me, threatens violence, and attempts to provoke confrontation. In September of 2024, respondent harassed and defamed me when he made a video saying that I have, and as y'all can see that word right there, as that is a false statement. Respondent repeatedly uses my name and frames me as someone he must confront, intimidate, or fight. He repeatedly blames me for his professional and online difficulties and suggests I am responsible for his consistent lack of prosperity on YouTube. These are nothing but delusions. Bizarrely, respondent takes videos that I make for my audience about a variety of topics personally in response with harassment, threats, or posts aimed at provoking conflict. On November the 29th of 2025, respondent posted a direct threatening message toward me on X.com stating, "I'ma stay on your neck, coward." This message was targeted at me by name and reflects escalation. Truly, these are just a few examples. It is so excessive that people have commented words to the effect of, "I need a restraining order," or "he is obsessed," numerous times. See Exhibit 6. And we will get into those exhibits at the bottom. Okay, so we're going to get into 7. Handwritten note during 2025 trial. Now, this might be some tea. There might be some tea. Y'all, we're going to have some tea right here. Okay, so let's get into it. So during the summer of 2025, while I was attending the Sean Combs, aka Diddy trial, respondent passed me a handwritten note literally during the trial. I did not reply. The note referenced a violent incident involving YouTubers and stated in part, "The situation in Las Vegas. The 2 YouTubers fighting over a copyright strike led to a man and his wife unalived. That woke me up. I have no plan to beef for clicks and views. However, I'm still upset that you go to the internet to call me a stalker. You're a stalker. Narrative isn't true and did significant damage to my digital representation. This note made me uncomfortable and uneasy because it shows respondent continuing to contact me, and even in a courthouse setting, and continuing the same fixation on me in my alleged damage to him. The note also was clearly a threat because if it was not, it would have not started with a story about 2 YouTubers, as we are, fighting, and one ended up dead. There was absolutely no other reason to write about that. And of course, to write me during a trial I am reporting on at all. See Exhibit 3. Okay, so we're going to get into number 8. Miami courthouse threats in-person confrontation in the following. Okay, so on November the 17th of 2025, as soon as respondent learned that I was going to be at Megan Thee Stallion versus Milagro trial the following day, on video, he threatened to fight me when he saw me the next day. On November the 18th of 2025, while I was covering that court case in Miami, Florida, respondent confronted me inside the courthouse bathroom. Respondent called me derogatory names, became aggressive and told me he was going to fight me. I did not respond and remained inside the bathroom stall because I feared escalation and I was alone in another state. An officer of the court was present and witnessed respondent's threatening conduct. He was an attorney. He confirmed with me in the bathroom that those comments were too for me. After returning to the courtroom, the presiding judge stopped proceedings to ask whether anyone had been threatened in the bathroom because I am informed and believe a bailiff told her about it. I did not speak up because I was shaking and feared escalating the situation in open court. But that currently unknown attorney stated in open court to the court that he in fact heard those threats in the bathroom. Chambers for the Honorable Cecilia M. Altanaga, United States District Judge, may be contacted at, and as y'all can see her phone number, regarding the threat and the lawyer stating he heard a threat in the bathroom. Later that same day, as soon as respondent spotted me, he recorded my movements outside the courthouse without my consent, broadcast my exact location on a live stream, rushed towards my facility, and verbally harassed me in public. This made me feel unsafe and surveilled. And as y'all can see, that is an excerpt from the live stream. Well, I'll go ahead and read it. I was going to say pause your screen, read it, and we're going to continue, but I'll go ahead and read it. This is what he stated as he live streamed so that he can feel safe. Like, why y'all listen to anybody why y'all listen to that man? Well, listen to a man. Let's walk past this N-word. I don't understand. I can't, there's jurors around, right? I don't understand it. I don't understand it. Why y'all listening to a man who don't do nothing but attack women, screaming with Petitioner now in camera view? But when N-words come to their door, they ain't got nothing to say. Why? That's BS. Why? This is BS. See Exhibit 2. And then says respondent next posted a video saying, oh, Jesus Christ. Now, why did he say this? You Nestle crunch face looking A-word, N-word, you botch body, teeth having A-word, F-word, A-word, N-word. Nobody gives a F-word about you. Talk about taking me to court. Me to court? You must got plenty of money and plenty of time, B-word. There won't be no peaceful resolution, B-word. That's what you wanted. On November the 20th of 2025, respondent reposted that live stream to his Twitter with the caption, Armon Wiggins, why do people talk big online but hide in real life? Next, on the same date, he tweeted, Armon Wiggins is jealous of me. Run a fade. Run a fade is slang for let's have a physical fight. On the same date, November the 20th, 2025, he also wrote, this ugly botch body, botch teeth, botch hair job, Armon Wiggins needs to do a friendly fade, which stands for have a physical fight with me. When respondent repeatedly confronts me, threatens me, and refuses to disengage after being told to stop, the conduct serves no legitimate purpose. It is not commentary. It is targeted, persistent, and intimidating. Courthouse are confined professional environments. Targeted intimidation, threats, and monitoring in that setting is especially alarming and inappropriate. I was appalled to learn recently that respondent has sued and is currently suing, harassing, and as y'all can see, we got 3 quotations here. So 1, a sitting judge, 2, a superior court, and 3, an attorney general of another state. Okay, let's get into 9. Service, retaliation, doxing, and escalation after notice. Respondent was personally served in this civil harassment restraining order matter on December the 7th of 2025 at approximately 2 p.m. After being served, or in other words, being provided actual notice that I have requested protection from his harassment, respondent escalated instead of de-escalating. Following being properly personally served on December the 9th of 2025, respondent stated publicly on a YouTube video that despite what the court order states about a hearing on December the 18th of 2025, there will not be no hearing on the 18th. So don't waste your time. Respondent seems to believe he knows how the court was scheduled or how the court will rule. Respondent is not an attorney and does not have a Juris Doctorate. However, He unlawfully states that he loves to practice law. He has even tweeted, Armon Wiggins don't know how much I love practicing law. Paperwork his A word to death. He gonna go broke. His statements about practicing law occur as well as his threats, aggressive confrontations, and statements about bullying me in court. In context, the statements are not aspirational. They are a part of a pattern of asserting dominance in legal spaces and suggesting that he has authority, standing, or entitlement to confront me there. On December the 10th of 2025, respondent stated publicly on a video that he was going to bully me in court. And here go an excerpt from that YouTube video. And I'm going to bully you in the court of law. I'm going to bully you in the court of law. That goes for anybody that comes out to me. I'm going to bully you. You didn't do your due diligence. You didn't see all the lawsuits that I fought, all the corporate executive attorneys that I battled for years on top of years with the same lawsuit before it was finalized. Oh, okay, I lost against these corporate attorneys, but you an N-word who write like my second grade cousin N-word. I'm going to bully the F word out of you in the court of law. After service, respondent posted and distributed court paperwork related to my request for protection that contained my personal information, including my home address and phone number. Republishing my personal information to an online audience serves no legitimate purpose and increased my fear for my safety. See Exhibit 1. After respondent published and distributed my personal information, I experienced harassment, including calls, texts, messages, public comments, reposts, and threats. I still have reasonable fear that individuals influenced by respondents' content would appear at my home or confront me in person. After service, respondent is using motions in court filings in this matter as an extension of his ongoing harassment. He is aware they have no legitimacy. They are intended to overwhelm, intimidate, and punish me for seeking protection. This misuse of the court process further demonstrates respondent's refusal to respect boundaries and his intent to continue harassing me through any available form. These filings serve to prolong contact and to force continued engagement. This conduct has compounded the emotional distress and fear that led me to seek court protection. After service, when respondent emailed me his motion in this case, he carbon copied bloggers, content creators, and influencers. The table below reflects the audience and reach of those people he specifically emailed, which is clearly in the millions. He did this to encourage others to harass me with him. One of the recipients did, in fact, discuss me in a negative way on her platform for approximately 25 minutes. See Exhibit 4. Now, here go a little chart. Y'all can pause y'all screen and take a look. So it looks like allegedly Cheryl World was contacted, Conscious TV, the Official King Payne, the Sean Davy Way Show, Neek at Night, Megan Cuniff, Unwind with Tasha K, Pam Esquire, the Law Intellect, and estimated total reach, as y'all can see, it broke it down by YouTube subscribers, Instagram followers, the highest YouTube video views, and in total YouTube views. All right, so we're going to keep scrolling. His continued goal is to use my name and likeness to harass me, to promote himself, and to mobilize third parties. Out of respect for third parties and their privacy, identifying information is redacted on some exhibits, but I can provide unredacted versions to the court if requested. And then number 10, additional conduct review. Well, I'm sorry. Additional conduct relevant to fear, vitality, and pattern. Respondent was banned from having a YouTube channel due to harassing others. He since created another channel anyway. Respondent has received public attention for confrontations with other individuals in public and courthouse adjacent settings, including an incident involving a well-known recording artist, Cardi B, in which respondent provoked her through offensive and harassing conduct, resulting in a public confrontation. I submit exhibits relating to this incident not to sensationalize respondent, but to demonstrate his established pattern of provoking conflict in public spaces, including around court proceedings in high stress environments. See Exhibit 7. Respondent currently has an open misdemeanor criminal case in Los Angeles Superior Court for Penal Code Section 242, which is battery. And as y'all can see there go the case number with future court dates scheduled. Respondent is presently on probation and was ordered to complete anger management courses. I am not submitting this to accuse respondent of the underlying conduct. I include this information because it heightens my fear that respondent is volatile and unpredictable while he continues targeting me directly and harassing me at court proceedings where I work. See Exhibit 8. Respondent was arrested in Highlands County, Florida for felony fraud conduct and in 2023 entered a plea to 6 counts of misrepresenting himself as qualified to practice law. And then there go the case number for that particular case there. This history is relevant because respondent repeatedly presents himself publicly publicly as engaging in or practicing law and also confronts me at courthouses. This, he said, these increase, I probably what he meant, but these increase my fear that he disregards legal boundaries and authority. In 2018, respondent was arrested and had a criminal case filed against him in Los Angeles County Superior Court for Penal Code Section 166A4, which is a criminal contempt of court, based on the willful violation of a lawful court order. And there goes the court case there. This is relevant to my fear that respondent may not comply with court orders, including any temporary or protective orders issued in this matter. In 2011, respondent was arrested in Broward County, Florida for disorderly conduct, and there go the case number there. In 2011, respondent had a criminal case filed in Los Angeles County Superior Court in which he pled to Penal Code Section 602.1A, intentionally obstructing or intimidating individuals conducting lawful business at a public establishment and refusing to leave after being asked. There go the court case there. This conduct is relevant because it mirrors respondent's repeated confrontations in public and courthouse settings and his refusal to disengage when boundaries are set. In 2008, respondent was arrested in Highlands County, Florida for domestic violence battery relating to his, this is some tea, y'all, his family and battering and later entering a plea. And there go the case number there. I am not offering this to reiterate past conduct, but because it contributes to my reasonable fear regarding respondent's vitality and escalation when emotionally triggered. Respondent has shown a consistent pattern of escalating his conduct when I disengage. When I block him, do not respond, or attempt to avoid him, his posting about me increases in volume and hostility. This pattern has continued over a 2-year period and demonstrates that respondent's behavior is not incidental, accidental, or isolated. A major part of my profession requires me to attend courthouses to report on legal proceedings. Respondent's history of confrontations in public and court-related spaces, combined with his refusal to disengage and prior disregard for court orders, make me fear that future confrontations are likely and could escalate into physical harm. Did y'all see that? Okay, we're just on page 14. We're just on page 14. We still got over 100 pages left to go. All right, so number 11, impact on my safety in work. A major part of my job requires me to be inside courthouses reporting on legal proceedings. I cannot avoid these locations, and I should not have to. Respondent has already confronted me in person at a courthouse in Miami and threatened violence. Respondent's posts and videos indicate that he intends to continue this harassing behavior. I am seeking protection from respondent threats, harassment, intimidation, following surveillance, and publication of my personal information. A restraining order is necessary so I can do my work safely, and so respondent is required to keep distance and stop confronting me, threatening me, filming my movements, and mobilizing third parties against me. I fear for my personal safety. I am requesting immediate protection due to the multi-year pattern of harassment and direct threats, the escalation after service, and the courthouse threat witness inside a federal courthouse. Yeah, I said it right. If the court does not order respondent to stay away from me, I believe respondent will continue escalating, which could lead to serious consequences for me. I am asking the court to intervene now so that this not become worse. Okay, so we're going to get into number 12. I seek orders prohibiting respondent from harassing, threatening, attacking, following, monitoring, surveilling, doxing, recording, or contacting me directly or indirectly, including through third parties and online platforms. I further seek orders prohibiting respondent from publishing, distributing, or reposting my personal identifying information, including my name, photo, home address, and phone number. I am requesting these orders so I can safely work and exist without being threatened, confronted, followed, or harassed in person or online. All relevant exhibits are attached and incorporated by reference. All right, so it says see exhibit list. So this is showing all the exhibit lists. Okay, so exhibit number 1. All right, y'all. So it looks like we're getting into the exhibits now. All right. Y'all see? Here go exhibit. Okay. So I'm just going to allow y'all to look, pause your screen. All right. Oh, let me take that off. Okay, y'all give me 1 second because he posted his personal information. So let me scroll past that. So it looks like when Denot posted it on, well, I see it clear as day right here. Denot posted this on Twitter. He redacted the information. However, when he was on YouTube, he did not redact the information. Okay, so let me come back on screen. Okay, we're just gonna keep scrolling. Oh, there goes again. So let me take this off screen real quick and scroll past this part. Okay, y'all see that? All right, y'all see that? Okay, so we're just gonna keep scrolling, y'all. We're gonna keep scrolling. Okay, exhibit 2, which is November the 18th of 2025. Respondent spotted me alone. He recorded my movements outside the courthouse without my consent, broadcasted my exact location on a live stream, rushed towards my vicinity, and verbally harassed me in public. Okay, so let's get into. Y'all see that? Okay, exhibit 3, which is a handwritten note. Y'all, we got some tea with this. Oh, there's some tea, y'all. We got some tea. We got some tea, y'all. We got some tea. There's some tea. Okay, so we got some tea right here, y'all. So this is what Armon is saying that Denot wrote him at the Diddy trial. Pause your screen, y'all. Read it. This is allegedly what Denot sent Armon. And that's the bottom of it. So pause your screen and take a look. All right, we're going to continue. Exhibit 4. After service, when respondent emailed me his motion in the case, he carbon copied bloggers, content creators, and influencers with the combined ability to reach tens of millions in an effort to encourage the others to harass me as well. Oh, baby, they got the good child. We got some tea. We got some tea, y'all. We got some tea. We got some tea. So we have the email here that was emailed out. And this is who he alleged sent the court filings to. Okay. Now, Exhibit 5, surveillance of me walking into the event in September of 2023 and then responding assaulting me inside of the event, followed by social media post about it. Y'all see? That was the video on X. Exhibit 6. Let's get into that. Oh, I forgot to look at the context. Successfully posting my name or likeness and harassing me because he understands that posting me is the way he can get views to his channel. Okay, and this is okay. So it shows that y'all see Cardi B, Ken Barbie, Nicki Minaj. Okay. Y'all see? Okay, y'all see? We're just looking at all the exhibits, y'all. We're looking at the exhibits. And some of these exhibits I just read, as y'all heard. Oh, there go Tasha K. And then he tagged. Oh, he tagged them. Do y'all see that? Lord. Okay. 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 Now I know this is sideways, which y'all can still make out. That's pretty much the video there. Okay. All right. And wow, this is a lot. This is a lot of exhibits. A lot of exhibits. Y'all just pause your screen and read along. Oh, look like the link. Okay, y'all see? A lot of exhibits. Mm, mm, mm. Okay, y'all, we're on page 60. We're going to this is page 62 of 134 pages. So we're halfway through. Halfway through. Remember, just pause your screen and read. Oh, see, yeah, man. All right, we're on page 77 now. So we're almost at the end. I know y'all don't like quietness. Y'all don't like when people quiet. That just y'all don't like that. I know. I know. But there's nothing to read. It's just pictures of the exhibits. So I do apologize, y'all. It looked like it's hmm. Now, we did see these two pictures along with the other three pictures because there was a third person. We did see that on the Knott's rebuttal when he posted a screenshot of his photo album. Okay. Now we're on page 91. So we're almost there, y'all. Now we all saw this. Okay. I just want to make sure y'all see it. This is a lot of exhibits. It looked like it's, excuse me, it looked like it's a repeat of some. And that's just pretty much, yeah, it looked like it's a repeat to some of them. Lesson, play with me and I will flood the algorithm. Oop, this is a do not. It says, I can do audio. Don't mention I tainted him with you. Make it seem like he just started. S word from nowhere. I'm about to dip. Love you. Have a good day. Don't let this man get you overworked. And it says, thank you so much. I can see the cutoff. I don't know who this was. Oh, Armon Cupcakes. Hmm. And this is Conscious TV. I remember seeing that video there. Okay. We're on page 112 now. So this is pretty much just a repeat. Up, that's when Cardi B. Now we was all watching this live. We all saw this happen. All right, and then this is what is this? Oh, this is the knots case. Okay, so oh girl, there's some tea. Y'all, there's some tea. We got some tea. There's some tea. Okay, so this is of his case back. This was 2014. Okay, this one was from 2019. Okay. This one's from 2019. This one's from 2019. Oh, respondent's criminal background, including presently on. This is his probation information, y'all. Okay, y'all gonna have to pause y'all screen. Oh, girl, this is some tea, girl. All right, we are at the end. This is the end, y'all. All right, so that's 134 pages. We got through it though. 140, 134, I'm sorry, pages. All right, guys, that's all of it. Now, if you like what you see here, make sure you hit the like button. It is free. Make sure you hit the subscribe button. It's also free. And tell your friends about it too. I appreciate everybody. Y'all have gotten me over 1,000 subscribers, and I appreciate all of y'all. I love y'all. I cannot do this without you. And as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, Just be mindful of who you come across and always have a healthy boundary set up. Okay? None of us have a dog in this fight. We're just seeing two content creators have a situation. But at the end of the day, we'll see how this plays out. I will stay on the case, since day one, I've stayed on the case. But as soon as there's another update, I will come out and I will give y'all that update. But until then, I'll see y'all in the next video. Peace.